Hello, everyone. Welcome to the Wednesday, August 28th, 2024 Measure 110 Oversight and Accountability meeting. Today we have some OHA updates. We have a presentation by the deflection program and some RFGA updates and some Q6 quarter 6 M110 data publish updates.
And then also, Melinda, before we get started, just want to also introduce myself for YouTube. My name's Samantha Byers, and I'm the Measure 110 Interim Executive Director, and I'll be assisting with facilitating the meeting today, along with our tri-chairs. The Oversight and Accountability Council welcomes and encourages community input. Members of the public are invited to submit public comments or get on our interested parties email list by emailing oha.measure110@oha.oregon.gov. That email address and more information about the council can be found on the Measure 110 OAC website. OAC members have asked that OHA and other staff who are present in the meeting space introduce themselves in the chat. Please share your role with the agency, and if you're a subject matter expert, your area of expertise. And so I will turn it over one more time. Melinda, if there's anything else or the tri-chairs that you'd like to say, and if not, we can begin with our presentations.
Is Cindy available to call for the agenda?
I'm doing it today.
Okay,
So,
thanks, Carly.
or not the agenda, attendance.
Attendance, that's
Yes.
what I meant.
Amy, I didn't see her here. Carlos? I think he's joining right now. Oh no. Oh, hi, Carlos.
Hello, I apologize.
No worries. Caroline?
Here.
It's just
Dharma?
Here.
Hubert? Saw him earlier. He may have gotten disconnected. Hunter?
here.
Jackie?
Here.
Jonathan?
Here.
Or Duncan, I'm sorry.
It's okay.
Keisha? No. Leticia?
Here.
Linda? Melinda?
Here.
Meredith?
Here.
Morgan? Nicole?
Here.
Hi, Nicole. Onisha? Ron?
Here.
And Ryan?
Here.
Sabrina?
I think she noted in the chat she'd be right
Okay.
back.
Perfect, thank you. Zeb?
I'm here.
Sam?
I'm here.
And Annalise?
Here.
Pete?
Hubert's
Back-
here too. Hubert.
Got you down, Hubert.
All right.
Thank you.
All right.
Back to Melinda.
Okay, hi, everyone. So we're gonna have a presentation about the deflection program put on by Ken. Have we let them in yet?
Yes, there are presenters in the waiting room, or?
They are coming in now.
Perfect, thank you. think I see Ken joined and Nancy. And Ken, I don't know if you would like to introduce yourself and begin the presentation.
Hi, Sam. Thank you. Yes, I'm here. And I assume for the present, I mean, I guess I don't have control of the presentation, so I'll just say next slide and somebody will move that forward for me. Great. Hi, good afternoon, everybody. My name is Ken Sanchagrin. I am the Executive Director of the Oregon Criminal Justice Commission, and Sam asked me to come here today to provide, a background and some information on HB 4002 and the grant work that the Commission is engaging in, along with OHA, on distributing funds related to deflection. So I'll dive right in, but I wanted to just mention that in my prior world, before coming to state government, I was a professor. And so I'm more than happy to take questions as we go along, as long as that's kind of the style of this committee. Just feel free to raise your hand and interrupt me, especially with some of this stuff. It's probably a little bit outside of the normal topics that you all cover here at your meetings. So let's go ahead and go to the next slide, please. So for a little bit of background, I just wanted to provide a tiny bit of information about the commission, the CJC that I work for. So the Oregon Criminal Justice Commission, we were formed in the mid-90s. We are an organization of around 37 staff, and our work is directed by a 9-person commission. And our mission that I put here on the slide is to improve the legitimacy, efficiency, and effectiveness of state and local criminal justice systems. And the way that we do that, we essentially wear 2 hats at CJC. The first is a granting hat. And so each biennium, we pass through around $100 million in public safety funding to various types of organizations and agencies across the state. And that ranges from programs like Justice Reinvestment that seek to limit prison usage and prison growth, through encouraging counties to take otherwise prison-bound individuals and supervise them in the community with funding that we provide for them, all the way to the complete other end of the coin. We also have, for example, a grant that targets organized retail theft and tries to intervene where organized crime is engaging in retail theft across our state. And so we really run the full continuum of different types of public safety funding. The other hat that we wear is a research and public policy hat. So around half of our agency is devoted to conducting research into best practices, into policy development. We like to think of ourselves as a state agency, local think tank for public safety related policy. And so as we go through, this presentation will be a mixture of some criminal justice policy information, a little bit of statistics here and there, and then also information on our grant program. I'll also mention that as we go through this, as I conclude with my presentation, we'll also be having a presentation by some partners that we have at Oregon, or at OHSU, Oregon Health and Sciences University. And the relationship that we have with them was really born out of this House Bill 4002 work that we're doing. They are the group that is helping us to provide technical assistance to our counties and to our 9 federally recognized tribes once that portion of the grant starts in a little bit. And so they'll be going after me, but that's really how we work together. We've hired them due to the expertise that they have in the area of deflection and addiction medicine, for example. So let's go ahead to the next slide, which I think is just a transition slide. So yeah, so what I'm going to do first is talk about House Bill 4002. But before I get into the individual portions of 4002 that are kind of relevant to our discussion today, I was going to provide a little bit of background about what the criminal justice system response has been to possession of controlled substances and other drug crimes in the past, more from a mechanical standpoint, just so we can understand what we're looking at in the future. So if we go to the next slide, please. Thank you. So very basic background on drug offenses. I'll try not to spend too much time here, but please stop me if you have questions. I actually cut these slides down from a longer, like hour-long presentation just on sentencing and drug crimes in the state. So usually when we refer to drug crimes, at least at the commission, we talk about controlled substances. That's the section of Oregon law that covers what we would usually call possession of drugs or drug dealing as well. So we follow, in essence, the Schedules 1 through 5 Federal Controlled Substances Controlled Act when it comes to our drug classification. However, as probably most of us know, we do have some unique aspects here in Oregon. And first, that is the fact that marijuana is legal. Marijuana has been decriminalized essentially since the 70s in the state, legal since 2015. And then also much more recently, the legalization in certain circumstances of psilocybin, or magic mushrooms, as some people refer to it. Those are the two places, at least pre-Measure 110, that we really differed from our other federal government, from our other states, as far as drug policy in the state. Essentially, drug offenses can be classified or broken down into three different categories. First, we have possession, which will be the primary focus of our discussion today. But then we also have delivery, which is the transfer of drugs from one individual to another, and also manufacturing. And delivery and manufacturing are treated in very similar ways from a sentencing standpoint, which we'll see in a few slides. But those are our three basic categories. One aspect of drug policy and drug sentencing that we see that cuts across all possession, delivering, and manufacturing, however, is this notion of a commercial drug offense. That'll be the consequences or the relevance of that will become a little bit clearer in a few slides. But I just wanted to mention that there is also this aspect that kind of sits in the background when it comes to how we punish and address substance use in the state. So we could move to the next slide, please. So essentially, we've gone through a few different steps of drug defelonization and drug decriminalization in the state over the past almost a decade now. So prior to 2017, the vast majority of drug convictions for possession were felonies. And when I say vast majority, we're talking about upper 90%. Essentially, the most common way for the system to interact with an individual caught possessing any amounts of drugs was to be charged and possibly convicted of a felony. There were some instances where individuals who were charged with felonies were then convicted of misdemeanors, but as I said, that was in the single digits as far as frequency before 2017. In 2017, however, House Bill 2355 was passed, and that bill, it was a landmark public safety bill that did two things. First, it created a first in the nation data reporting requirement for all officer-initiated traffic and pedestrian stops to examine police behavior for indicators of racial disparities. That's a program that is administered by CJC. You can read our annual reports online if you're curious about that. But then also 2355 also defelonized possession of controlled substances for a new category of possession. This was the first time we really saw a reference to user quantities of drugs for individuals. And it was those user quantities that were defelonized for individuals who either did not have pre-existing criminal records or who possessed those small amounts. And so essentially we went from a single tier felony system to a two-tier felony class A misdemeanor system focused on those user quantities of drugs, smaller amounts for personal use. And what we really saw after 2017 was that first, overall convictions for possession and arrest for possession, they both fell. It wasn't just that there was a substitution where the folks we would expect to be charged with misdemeanors were charged with misdemeanors. The overall rate of enforcement fell. And after about a year or so, we saw a 50-50 split between felonies and misdemeanors as far as possession is concerned. We also saw, which was expected and was a very positive outcome, a substantial reduction in the number of first-time felons who were encountered in the system. Before 2017, possession of controlled substances was one of the most common ways that individuals became felons for the first time entering into the criminal justice system. And that was reduced, not completely eliminated, but reduced pretty substantially through the efforts of 2355. Now, what ballot measure 110 did when it was created, the way that it was written, is it essentially created a three-tier system. And it essentially took everything that we had within that felony and misdemeanor classification and shifted it downward one level. And so with the introduction of the E violation, that would have been our old Class A misdemeanors. And then many of our old felonies went into a Class A misdemeanor, there. Really what was only left at the end after the passage of ballot measure 110 were really those felony commercial drug offenses or possession of very, very, very large quantities of drugs. Next slide, please. So this slide has a lot going on, and I promise I'm not going to cover every single thing in it, but I wanted to make sure you had it in your packet just for future reference. So thinking for a moment about how we would actually then punish according to that framework. So we have our felony charges, we have our misdemeanor charges, and our Class E violations. I'll leave the Class E violations to the side because I know that that's really the province of this committee. So I think that that's something that we don't have to go over. But working backwards, misdemeanors are not punished according to sentencing guidelines. However, our felonies are. And what that means when I say sentencing guidelines is we have a structured system in the state that is designed to lay out a somewhat consistent either prison term or probation term for individuals depending on the seriousness of the felony that they commit and then their criminal history. And that's done through this very simplistic grid that we have here on the slide. Crime seriousness ranges from 1 to 11. Crime seriousness is set either by the legislature when they create a new crime or modify an existing crime. If the legislature chooses not to set a crime seriousness number, then that responsibility actually falls to the Criminal Justice Commission, because one of the many hats that we wear is we're actually the state sentencing commission as well. Criminal history, which is described here on the slide in a little bit more detail, is the other side of this matrix, ranging from somebody with no record, who would be at a category I, so this is from A through I, all the way to individuals who have pretty substantial person felony records at that A level. And the intersection of your crime seriousness and your criminal history is what will either be your presumptive prison or your presumptive probation numbers. So you'll notice that there are a lot of boxes kind of on the top and to the left-hand side of the slide that are yellow. Those are all presumptive prison boxes, and those are all prison sentences represented in months in those yellow boxes. However, below a bolded line that you'll see as we shade towards the bottom right-hand corner of the sentencing grid, those are presumptive probation boxes. And so where you fall on that grid is really going to determine the type of punishment that you receive. And now on the next slide, if we go to the next one, we'll talk about how drug offenses fit into those. So another slide with a lot of things going on. But essentially, when we go back to our original categorization of possession offenses, delivery, and manufacturing offenses, this is the basic framework that existed before HB 4002 as far as the types of sentences that individuals would likely receive if they engaged in these different types of behavior. Now, one category that I did leave off of here is that if you are an individual who was caught possessing drugs at the felony level, if none of the other things you see on this slide are true, then you fall into a crime seriousness of number 1. And essentially at a 1, that's all presumptive probation. So I didn't include that on the slide here. However, once you begin to possess either substantial quantities of drugs or possess drugs in combination with a commercial drug offense, or especially once you move into the delivery or manufacturing realm, that's how you begin to move up in crime seriousness as far as the crime categories are concerned. And certainly when you look at the the left-hand side of this slide, and you see these delivery or manufacturing charges with large amounts of drugs, that's where essentially you're falling into a presumptive prison spot off the bat. Crime category 6 or crime category 4, on the other hand, that's where you're going to find some possession charges as well, or delivery and manufacturing offenses that don't fit into the other boxes. That's where you may be in presumptive prison or presumptive probation, but that's largely determined by criminal history under the guidelines. Next slide, please. So let's jump over to recriminalization now, and then we'll come back to some of the differentiation between possession, delivery, and manufacturing. So on under HB 4002, several changes were made, actually many other changes in addition to this, but I think these are the ones that are the most relevant for us today. The first is that with regards to drug possession, the legislature created what is known as an unranked drug enforcement misdemeanor for drug possession. The fact that it's unranked simply means that the legislature wanted to pick out or to define its own set of punishment standards for this crime individually, as opposed to having it fall into the greater structure that we might find with A, B, and C misdemeanors, A, B, and C felonies, or into something like the grid. In addition to that, the e-violation structure was repealed as the drug possession unranked misdemeanor comes into effect, and that takes place on Sunday, if I remember my dates correctly. I think that's the 1st of September. Or no, is that Saturday? I think it's Saturday. In addition to that, there were some changes to drug delivery. And we'll go into what those changes were in a couple minutes, but essentially there's been some court cases concerning drug delivery that led to a pretty substantial reduction in the number of delivery convictions across the state. So that really played into a lot of the narratives that we've seen in the media about the difficulties in prosecuting drug dealers. There was also an expansion of proximity penalties, essentially, for drug dealing, which we'll cover in just a few minutes. And then a couple other changes, which we'll also cover today. HB 4002 also created a grant program and essentially a motivation for counties to create what are known as deflection programs. The bill also expanded the use of what is known as conditional discharge, and those are for individuals who are in the criminal justice system, so they've not been deflected. We'll talk about what that means in a few minutes as well. But then it also expanded the availability and use of expungement. Next slide, please. So here is the detail about the new drug enforcement misdemeanor. So we have that framework kind of reproduced from earlier here, where the folks who are falling into the drug enforcement misdemeanor are those who are possessing a user quantity of drugs. Under a drug enforcement misdemeanor, somebody who is convicted of this U misdemeanor, as we call it, the sentencing structure, like I said, is defined in statute. It's unique to itself. It's not found with any other types of sentences that we see in our system here in Oregon. It's similar to it, but it just has some interesting little pieces here. So what the sentencing structure is that courts may do one of two things on the front end. They may either impose a 180-day jail sentence for that individual, or the individual could go and do an 18-month probation sentence, which in theory could be extended by agreement with the parties, but at least on the front end, it's going to be an 18-month probation sentence. If an individual chooses the probation route, if they have a probation violation during the 18-month term, in total across the entire term, up to 30 days of jail sanctions could be ordered by a court. Oftentimes on probation, you would see this happening in small chunks, depending on the severity of the violation. If probation is revoked, then a 180 jail sentence may be imposed for the individual. But whether for structured sanctions or if it's a 180-day jail sentence, any jail sentence must include an option to release directly to treatment before the end of the jail term if treatment is both necessitated, but then also available. And then finally, courts are prohibited from imposing fines or fees on individuals convicted of a drug enforcement misdemeanor. Next slide, please. Pivoting over to drug delivery for a moment, I mentioned earlier that when it comes to drug delivery, there were some concerns that came up through some legal cases that occurred during the past few years related to drug delivery that 4002 is seeking to address. So in 2021 and 2023, there was first a Court of Appeals case here in Oregon, and then an affirmation by the Oregon Supreme Court, which really changed the legal landscape for delivery of controlled substances. So stretching back to the late 80s, the common practice in Oregon has been to treat the possession of large quantities of drugs with some sort of indicator of intent to deliver as sufficient to prove an attempted delivery. And that was decided in a court case called State versus Boyd, and they were oftentimes referred to as Boyd deliveries. They are essentially easier deliveries to prove than a fully completed delivery because nothing had to change hands, or another like a traditional attempted delivery because you did not have to prove that an individual took a substantial step to actually engage in the delivery of drugs. You just had to show that intent, which also could be inferred at times by those large amounts of drugs that were being possessed. So in 2021, State versus Hubble overturned this entire approach. And then that Hubble doctrine was affirmed by the Supreme Court in 2023. And the operative language that was provided by the Supreme Court was it is not established, or an attempted transfer is not established by evidence that a person possessed a large quantity of drugs and had the general intent to transfer it at some undetermined future time. And so this, when combined with COVID, we can see here on the right-hand side of the slide, led to a very, very substantial reduction in the number of successful drug delivery cases that were prosecuted across the state over the past several years. So we'll see that before COVID and before the decisions in these cases back around 2019, we would have seen an average of about 85 drug delivery cases or convictions per month across the state. However, we look down to our most recent time period, and that's fallen not quite to single digits, but pretty close. As both we came out of COVID, we could see that initial large dip during the COVID period with a slight rebound before these cases were decided. Next slide, please. And so one of the aspects of HB 4002 was the legislature explicitly returning to the older Boyd definition of delivery. So the Supreme Court was merely interpreting the current statutes on the book. So this was not like a constitutional case or anything. And so that meant that the legislature was free to actually define deliveries in a different way. And that's what they sought to do, was that, again, an attempted drug delivery could include possession with the intent to transfer to another person, with the aim toward restoring the system to what it was prior to these court decisions in 2021 and 2023. As I mentioned briefly earlier, the court also added new proximity restrictions to drug delivery, and those are tied into our sentencing structure that we'll see on the next slide. But those new restrictions essentially include, and by restrictions, it means essentially there is an increased penalty for engaging in these three different types of behavior. But if you engage in delivery, if you conduct a delivery within 30 feet of a public park, 500 feet of a temporary residence shelter, or 500 feet of a treatment facility, those result in more severe, or at least a higher crime category. So most likely a more severe punishment for an individual. So if we could go to the next slide, we'll see where that fits into our structure from before. Essentially, our crime categories 8, 9, 10, 6, and 4 are the same. However, if there is a delivery that is occurring within those geographic bounds, now what would have been a crime category 4 delivery in the past is elevated to a 5. So basically, any delivery that's not counted on the rest of the grid here occurring within those geographic areas, that's what goes to a 5. You go from a 6 to a 7 if you're engaging in delivery for consideration, and you're within the amount of space defined by statute there for these types of deliveries for those 3 new additions. Now, this is also where you could, this would be the same as, or it was thought of similarly to delivery within 1,000 feet of a school. That was the one geographic proximity limitation that we had before. Next slide, please. Now we'll get a little bit more into the grant pieces. So one of the intentions of the legislature through this process was that if it was going to engage in recriminalization, was that there continue to be, or that they would want to create new opportunities or off-ramps for individuals to not become involved in this, into the criminal justice system, and to hopefully retain a connection into the behavioral health, public health system. And so one of the off-ramps, or the initial off-ramp that was created, was the use of these new deflection programs. And so these programs are supposed to be county-based programs and or tribal-based programs. And they are supposed to be stood up by local governments using either their own local money or funding provided by the Criminal Justice Commission through this new Oregon Behavioral Health Deflection Grant Program. Now, deflection was defined very broadly in statute. The definition is right here on the slide. It's basically a collaborative program between law enforcement and behavioral health entities that assist individuals with SUD needs to create community pathways to treatment, recovery, housing, services, and supports. As I mentioned, we at CJC administer this program. However, the decision-making body that oversees it is a committee that is housed within CJC, but also exists somewhat independently of it. So it is overseen by what we call the Impacts Committee. That's a long acronym that stands for Improving People's Access to Community-Based Treatment Supports and Services. That is a committee that is co-chaired by myself and Samantha Byers, who you all know very well. And if we could go to the next slide, please. The reason why this, oh shoot, did I forget I must have forgotten the roster. I can send you all the roster. We'll go back just for a moment so we don't get lost on this one. The Impacts Committee was selected because unlike our commission, which you saw was a 9-person body at the outset, our commission is pretty much exclusively criminal justice focused when you look at the expertise of the individuals who are serving on the commission. The Impacts Grant Review Committee, however, in the same spirit that it's co-chaired by myself and Sam from OHA, is that it has expertise that really cuts across our 2 siloed areas of government. So we have folks with lived experience. We have folks who, are the administrators of hospitals or who run local treatment programs. And that was done on purpose so that we could have input from both sides of the system as we tried to set up a program that is beneficial, and while it has characteristics from each side, is also able to maximize the benefits that each side can bring. So let's go to the next slide. This is a little bit of a primer on deflection and how it's defined on the little flow chart. So next slide, please. Thank you. So ideally, what we want to see when it comes to deflection, though we have to note this with the caveat that I mentioned that deflection statutorily is very broadly defined, is if we have an individual who is either suspected of or who is found possessing drugs, then depending on the county eligibility criteria that are set, that we'll talk about in a few minutes for who is eligible for deflection programs, what we ideally want to see is that individual being deflected by law enforcement right during that initial interaction. And so what that really means by deflection is that instead of being taken into a criminal justice system intervention, like being booked into jail or being cited and released, that individual is either cited to some sort of future meeting with treatment staff, or in some counties is able to be taken to some sort of location to begin to receive immediate assessments and other services that may meet their basic needs. So a good example of this is in Deschutes County. They have the Deschutes County Center that is co-located actually right next to the jail, and that was done purposefully to hopefully provide a strong motivation for law enforcement to use it as an alternative to the very difficult and long booking process. And so individuals who have a behavioral health need, who have mental or substance use needs, can be taken directly to the center, which can provide a 23-hour respite. It can provide a nice place for the individual to stay during that time, food, water, like I said, behavioral health assessments, other types of services that we would not normally think of as being criminal justice services. And so ideally, that's the model that we would want to employ for deflection. An individual may be encountered by a law enforcement officer, but is immediately deflected into a public health response, and then hopefully can engage in a public health pathway to recovery without ever having to touch the criminal justice system. Now, you'll notice there are a lot more arrows on this flow chart than simply that one pathway that I just mentioned. And that's partially because of how both deflection is thought of in the grander scheme of things, but then also based on how the law was written in Oregon as far as what qualifies as a deflection program. Now, I'm thinking that probably a lot of folks on this meeting have heard of the LEAD program in Seattle. LEAD is been traditionally referred to as law enforcement assisted diversion. However, they have since begun to refine their name up there in Seattle as well. I'd be remiss if I didn't mention that. But essentially, in the Seattle LEAD program, that first pathway we just mentioned, where a law enforcement officer is able to take you someplace or is able to enroll you into a non-criminal justice system type of program, that's one of the pathways that they utilize. In addition, however, if a physical custody arrest needs to be made at a given moment for an individual who has drugs, the Seattle LEAD program, what they will do is they will actually make that physical custody arrest, take the individual to where they would be booked, and then provide them with the choice. You can enroll in LEAD, and I'll let you walk out that door right now to the LEAD folks who will talk to you, or we can continue with the booking process. That is the model that Seattle LEAD employs, and we do have a few of our counties here in the state who are looking to employ a somewhat similar model there, to where there may be an arrest, which could lead to an arraignment. This is the bottom part of the flow chart now. However, the goal would be, before that arraignment ever occurs, that the individual would be connected into a local deflection program so that they could then hopefully continue on that public health pathway towards recovery and not proceed through the criminal justice process. Next slide, please. However, if there are individuals who are unable to engage in deflection, whether it's because they choose not to, whether it's because they have charges that would make them ineligible to engage in deflection, which we'll talk about in a few minutes, the other off-ramp that 4002 sought to bolster is a program that is known as conditional discharge. And you'll see on the flow chart here, it says that if an arraignment occurs, conditional discharge must be offered. That's really the key. And if we go to the next slide, we'll kind of draw that out a little bit more. So conditional discharge is a program that's been around for many years, and so it pre-existed HB 4002. And what conditional discharge essentially is that for individuals who are facing certain drug charges, subject to a prosecutor's approval, they could enter into a conditional discharge agreement, which means that they do not plead guilty and they do not plead no contest. Rather, they just enter directly into a probation agreement while waiving certain rights, like the right to a speedy trial, for example. And then they essentially engage in a term of probation, at the end of which, if they're successful, the charges are dismissed, which is why they don't plead guilty or don't plead no contest in the first place. They're essentially dismissed in their entirety. However, that's a program that, as you'll note, first, it was subject to prosecutor's approval. That means it was really something that needed to be initiated by the prosecutor's office. A defense attorney or a defendant could ask for it, but it was really up to the prosecutors if that was something that was going to happen. And so this was a program that was, I guess it's hard to say if it was underutilized, but certainly it was not utilized as frequently as many might expect, given the benefits that it could provide. So, for example, in the share of cases in 2016 and 2017 that went to conditional discharge were only around 25%. And those numbers actually fell after the defelonization work that was done in 2017. Completion rates are about 50% to 60%, depending on the year, as far as those are people who did not fail the program. So they were the ones who were getting their charges dismissed. But it was really a small slice of individuals who are charged with drug crimes who are going into the conditional discharge program. So under House Bill 4002, essentially all individuals charged with a drug enforcement misdemeanor are eligible for conditional discharge. And that includes individuals charged with the drug enforcement misdemeanor who also have other co-occurring crimes. So if an individual is possessing drugs while committing a burglary or a theft, for example, that would not prevent the conditional discharge from being applied to that drug enforcement misdemeanor for that individual. And so, as we saw in the old system, conditional discharge had to be offered by prosecutors, but now defendants of those those unclassified misdemeanors are per se eligible. The only way that they would not be eligible is prosecutors can object, but then that would lead to a court hearing where there would have to be evidence, some sort of evidence provided to indicate why this individual should not receive a conditional discharge. And so what we expected the commission, especially from a data standpoint, is to see this program being used much more frequently than we saw in the past. Next slide, please. Among the other policy changes, I've already mentioned very briefly expungement. So now at each stage of the process, whether that's deflection, conditional discharge, or even a full conviction, even not resulting from a conditional discharge, there are new requirements for, I would usually put automatic expungement in quotation marks. It won't be fully automated from the beginning. That's something that's very difficult to do, but it's much more automated than it has been in the past. And there are some pretty strict timelines that are mandated by statute for certain records to be sealed or for other information to be set aside through the legal process, trying to take some of the responsibility off of individuals who have been convicted or have been arrested for these offenses and placing those on the state. In addition to that, there was the creation of a second grant program, also administered by CJC, that would increase the availability of jail-based MOUD treatment within local correctional facilities. That it was a $10 million investment for that program, and we are working to get that grant program rolled out now. So that's just another little tidbit related to some of the work and the monies that you all award here at your committee. Next slide, please. So focusing specifically on the deflection grant now, we can go to the next slide. So as I said, created, this is kind of a duplicative slide here, I just realized, created by 4002. Here's our definition again. Let's move on to the next one. Oh, there's my roster. I knew I had it in here somewhere. Oh, and I see I have a question from Melinda. Go ahead, Melinda.
Yeah, so I have a question. Does this, is it just for at the state level or is it at the federal level for the expungements?
Oh, that would be at the state level.
Okay, thank you.
Yes. Yep, thank you for the question. So here's the roster of our deflection impacts grant review committee. I'll just pause here for a moment so you can see the types of positions there. As I mentioned, though, it's one of our more representative committees as far as representing outside of the criminal justice system compared like to our commission, for example. So next slide, please. So the basic eligibility criteria, these are the folks or the types of organizations that can apply under our grant process. These are all statutory requirements. So essentially the types of organizations that the Criminal Justice Commission awards to for deflection grants are either counties or federally recognized tribes, consortia of counties or counties and tribes or tribes and tribes can apply together. We have one instance of that where two counties have band together to create a program across their two jurisdictions. But essentially it needs to be a unit of government that applies to us at CJC. However, they can then award monies to other non-governmental organizations, but we work directly with the other governmental entities. There must be coordination with the local district attorney, with local law enforcement, community, the community mental health organization within the county, and at least one provider from their burn. They must have what is known as a program coordinator who oversees the administration of the program and also acts as that central node between the local DA, local law enforcement, the CMHP, and the burn folks. And then also there is a requirement that they must track and report data to CJC on their deflection programs. The types of expenses that are allowed are very, very wide ranging. It can be anything related to program operation. It can be individuals, so law enforcement employees, deputy DAs, behavioral health workers, peer navigators, mobile crisis workers. They can use money for behavioral health workforce development, and then also, if needed, for capital construction for things like sobering centers, drop-off centers, deflection centers, whatever we want to call those there. In addition, there is the option for counties to engage in a planning grant, which means that they can take some time, receive money from CJC to actually do planning, and figure out what type of program they want to deploy. We've been asked to roll this program out very, very quickly, and so we wanted to make sure that counties who are not quite ready did not feel shut out of the process. Next slide, please. So the total available funding for this program was almost $21 million. We are required statutorily to determine as a impact grant review committee the share of funds that are available to our local tribal partners. And so the day after HB 4002 was signed, the impacts grant review committee met, and we elected for this first biennium to set aside 10% of all funds, so around $2 million in total for our 9 local tribes. In addition to that, we selected $150,000 to be held back for evaluation of the program rollout, which left the remainder about $18.5 million to be dispersed to counties. Next slide, please. And so those funds are dispersed, and this is really our direct tie-in to the work that you all do here at the Oversight Committee. So the Measure 110 funding formula that you all administer was statutorily selected as the basis for the funding formula that we would apply to our counties for that $18.5 million. Now, our formula would look a little bit different than yours because we also statutorily have a $150,000 funding floor that is provided for counties that otherwise would not receive that amount of money. And so the percentage shares may look a tiny bit different compared to what you all have, but essentially the math on the back end adheres to the formula that you all set. And we worked with OHA to get all of the mathematical information we would need to do that. What I would also note here is that counties are not required to apply for behavioral health deflection grants. And so you'll see several counties on here, there's 8 total, who did not apply. And so their funds, according to the statute, were essentially redistributed to the other counties who did apply using the funding formula that you all define. And so you'll notice that Coos, Curry, Douglas, Jefferson, Lake, Sherman, Wallowa, and Wheeler are our counties that did not apply, and their funding totaled around 800, maybe 850 as far as an amount, and so that was the amount of money that was redistributed to the other counties. Next slide, please. So to access this money, we engaged in a 2-stage process. This is a little bit old news now, and so it's not quite as interesting because we've made it a lot farther. But during the development of HB 4002, the Oregon legislature reached out to all of the counties across the state and tried to identify which counties may be willing to move forward with deflection as a concept as that bill was taking shape. And so 23 counties submitted letters to the legislature saying that they were on board with engaging in deflection. And those 23 counties were then essentially labeled as early adopter counties. And in the companion bill to HB 4002, which contained all of the funding, HB 5204, that bill essentially, but then after that, and somewhat overlapping, we've run more of a full standard process for all counties to access should they so choose. And in the end, as I mentioned, we had 28 counties. They represent 27 programs because Hood River and Wasco decided to combine together. They applied for the full process. There were a few counties who were in the early adoption process who did not want to apply early, and so they waited for the full process. There was one early adopter county who has since decided to not stand up a deflection program. And we made decisions for all 27 programs over a 4-day period. All programs were approved. And you can see the counties here, just if you're more of a visual person like I am, on the map here to my right. Next slide, please. So what do these programs look like? I mentioned the Seattle LEAD program earlier. primarily because most of our counties are seeking to stand up what we would think of as a lead type program. We've tried to call them officer intervention programs because not all of them have all of the lead characteristics that we would be looking for to be able to really call themselves lead like Seattle engages in. But in addition to officer intervention, some of the programs also proposed or wanted to utilize their pre-existing mobile crisis teams, so perhaps provide some funding there. A few either wanted to open or support their local behavioral health deflection centers. And again, this could be that just because a county does not have a check mark next to them doesn't mean they don't have one. So Deschutes County, I already mentioned, they have a center. However, they're not funding it through this program. So any X that you see here is what a county is trying to fund through our dollars. But then in addition to that, there are a number of counties that chose a much more DA or district attorney led approach. And so those are the DA diversion programs that we have checked off here. Those are the ones that really, when we were thinking about that flow chart a few slides ago and the bottom path that could lead to arraignment before deflection occurs, that's where we really see those DA diversion programs. That's the spot that they occupy as opposed to that top, more traditional deflection route. Next slide, please. So when are these programs going to become operational? Most of the programs, so about 60%, aim to be operational by the end of this week. I think that most of them will be rolling out on a more staged basis than that. But essentially what we're looking for at the commission is which programs seek to be or plan to be operational by the end of the year. Because we know that we're building this plane while we're flying it. All the counties are building their little planes while they are flying them. And so we're trying to give them some grace as far as getting these stood up. We'd like to see them operative as soon as possible, but we also don't want to rush things. And I think Multnomah County is a good example of that, where it's been a little bit of a moving target as to when each piece is going to come into effect. 8 counties are estimating their programs will come online after recriminalization takes place. And so we're looking at that, December, January time period. Essentially all programs that hope to be or plan to be operational by the end of the year, we've thrown into an operational bucket. That's our expectation. The other counties that are looking more towards next year are in that planning grant bucket. And those are ones that we're working with to ensure that they develop a strong program, but we know that they're not going to be operational through the end of the year. Next slide, please. So here's where we're getting into some of the stickier pieces that may lead to a number of questions. So I mentioned earlier when we even looked at that flow chart that some people are going to be eligible for deflection and some won't. This is, according to the statute, a local decision. And so we at the commission can advise on what best practices are as far as who should be eligible for these types of programs, but they're defined by the local jurisdiction. And so when we looked at the types of eligibility criteria that the counties came up with, they essentially fell into 3 buckets. And those buckets could almost be divided perfectly into thirds, actually. And so you'd find about 8 counties, give or take a county, in each of these categories. So the first is, and you can see that most people, or most counties rather, are focusing on the possession unranked misdemeanor population. And so we can see that a number of counties essentially are focused solely on individuals who are charged with possession. And it has to be charged with a standalone possession. So that's why I mentioned earlier that for conditional discharge, an individual who's convicted of multiple counts or multiple crimes is still eligible for conditional discharge. In deflection, a lot of counties are making individuals who have multiple charges in a given event ineligible for deflection. So that would be that example I gave earlier, where if somebody is committing a burglary and then they are found to be possessing drugs, or a theft and found to be possessing drugs, then those individuals would not be eligible for deflection. They would be routed through the more traditional criminal justice system process. Now, there are some counties, around 8 of them, who are putting even further restrictions on on that PCS group. So that's our second category here, the second bullet, the PCS with conditions. So in those cases, we're looking at, this is an example that cuts across a couple different counties. And so certainly they start with the presumption that they are only taking folks who have a standalone possession charge, but also that they not be currently on supervision. So that would either be probation or post-prison supervision, that they have no other pending charges, no prior convictions for violent felonies. Some counties set that as a lifetime look back. Some look back for 10 years, on the other hand. There are some counties that have geographic limitations, so that the person must be a county resident to be eligible for deflection. And then some set up some restrictions that you could not have prior convictions for delivery or for manufacturing. The final group of counties, the final third, are the ones that, unlike the first two, are willing to consider a wider breadth of charges. And so these counties are focusing on individuals who are charged with possession of controlled substances, but they are also looking beyond it. Some of them to just quality of life crimes, as they term them. And so that's going to be lower level misdemeanors, and in some counties, some lower level property felonies. But then some also listed out these specific crimes that they would also consider. So we're looking at the ones here, for example, loitering, misdemeanor theft, misdemeanor property destruction, prostitution, trespassing, and the like. Next slide, please. So maybe even squishier than the definition of the eligible population is definitions of success across programs. And I call them squishy because while I could easily categorize the county approaches into 3 buckets on the previous slide for eligibility, for success, there's really not a pattern that I could discern when I look at the applications. And so every county right now is looking at success slightly differently. And some have rather rigorous requirements, and some have less rigorous requirements, which will likely result in some significant differences across the state. So some are really focused on just accessing or participating in deflection services within a certain amount of time. So some would say within 2 weeks, you have to either access or participate in the services, and that's it. Or that you must access services and then complete whatever the recommendation is of that deflection service within 3 months. That's one end. Another would be low risk individuals completing an online or in-person counseling program. But then on the other side, there are some more stringent requirements, such as engaging in treatment for a minimum of 90 days, or in some cases, those actually also include total abstinence for a certain period of time, maybe upwards of 90 days, which we know is going to be very, very challenging for individuals with serious SUD issues to meet. And then others are a little bit even more squishy, allowing for essentially for the discretion of treatment staff to assess an individual and whether they're making adequate progress, or some even just say that, well, success is going to be based on what the client needs to be successful, and that will be set on a case-by-case basis. But this is certainly an area that we're paying a lot of attention to. Again, I mentioned earlier that we at the commission, our primary role statutorily that we can play in this process is to advise on best practices, which we are planning to do. But we don't really have an administrative ability to force counties or other grantees into certain definitions of success, for example. Next slide, please. So one question I got specifically when preparing for this presentation was what the money breakdown looks like and what are the types of services that we'll be funding, and especially, to what extent do they touch on the work that you all are doing on your committee. And so what we've begun to build, we just finished making awards literally just a week or so ago. So what we have been working on building is a data dashboard, an interactive dashboard that has all of the expenses that we have awarded broken down into big buckets, such as behavioral health versus public safety, but then also just county by county listing every single expense that has been approved. That's something that's under construction right now, and we hope to have finished within the next week or so. And so that's something I'll be happy to pass on to your committee staff so they can distribute to you for a much more granular detail than I'm able to provide today. But what I can provide is a preliminary allocation breakdown that we have here on the right-hand side. Around 60% of our funds, and this may surprise Sam, my co-chair here, because it actually surprised me that it fell this way. But around 60% of our funds are actually devoted to behavioral health costs, very broadly defined. And so some examples of those broadly defined behavioral health costs are case managers and case management, peer navigators, housing, and that could be immediate or short-term housing. It could be rental assistance. Funding devoted to stabilization centers, transportation for individuals, and that could range from actual transportation of an individual or even bus passes to get to different treatment, to different treatment appointments or to deflection appointments. Addiction specialists, a couple QMHPs, clients supports and incentives, medication for a couple counties, mobile crisis vehicles, and even food. Around a quarter of our grant funds are devoted directly to public safety organizations and agencies. And so that would be mostly for positions like district attorneys, deflection program coordinators, which are a requirement of the statute. Those could actually be found sometimes in the behavioral health bucket as well. We were really sticking those depending on what type of organization was going to be the one housing that position. But then also drug testing, sheriff's deputies, lead navigators, paralegals, and legal secretaries. And then we also have another bucket of, around 18% or so that is the other category. But I would encourage you, if you're really interested here, like I said, we'll pass on our full dashboard that gives you a complete breakdown when we have that go live. Next slide, please. So what are our next steps? We have currently provided all of our applicants with a notice to intent to award, which initiated a 14-day protest period. Hopefully, because they were all awarded funds, we don't receive any protests, and contracting can begin as soon as that protest period concludes, which essentially corresponds with next week. And so that's where we'll begin contracting and sending money out to counties. We're also working on programmatic and county-specific feedback for applicants. So as our grant review committee reviewed the applications from our counties, there were a lot of questions and concerns that the committee had. Some of those, hopefully you can kind of detect my tone as I've gone through, there were certainly concerns about the stringent eligibility criteria that a number of counties decided to employ. Certainly there's a lot of concern about the wide variety of definitions of success. And for some of our counties, there was a combination of both relatively stringent entry requirements, but then also relatively stringent exit requirements. Those ones probably worry us the most. And so what our committee is asking from the counties is for them to provide additional clarification. In some cases, we're asking them to provide some justification on why they would like to be as restrictive as they are. A lot of our counties need to do a little bit better at actually very explicitly describing the linkages between the law enforcement intervention and the public health intervention. So how do we actually build that bridge? I think in some of the applications, there was a bit of almost an assumption that if we build it, they will come. However, that's not something that we're really willing to hang our hat on. We'd like to do a little bit better at defining that linkage than that. We also know that a number of our programs are still in the planning stage, and so we'll need information from them as they go through and actually put some more detail on the foundation that they're building now. But then also, because of the way that we had to recalculate the funding formula, some of our counties are eligible for their up to amount to receive a bit more money than they thought in the beginning. And so we would like to see what they would like to spend their additional funds on. And that ranges from some counties, because it was, again, based on the formula, that may have received, $10,000 or less of additional money. Multnomah County, though, if I recall the numbers correctly, will receive around $400,000 more than they originally received. And so that's a pretty substantial amount of money for them. And so we'll be waiting to hear back about what they'd like to spend that on. And I believe that's my last slide. Let's go to the next slide just in case it's not. Oh yeah, that's just my contact slide. Certainly happy to take questions now. But then also, if you have follow-up questions, I know I just threw a lot of information at you. Please feel free to reach out by email or by phone with any specifics that you have. And I appreciate you letting me take 40 minutes of your time today.
Hi, so do we have any questions for Ken?
Ron, go ahead.
Yeah, hi. Thank you very much. It's a wonderful presentation, very detailed. Really appreciate that level of detail. One of the things that I noticed was that this is for the $18 million this time is it said one-time funding. So what is the continuation? What is the plan for continuing the program beyond 1 year?
Thank you, Ron. First, thank you for the kind words. I appreciate that very much. But that's a great question. So, the way that the funding was rolled out in this short session was they essentially did only give us one-time funding, and that normally is something here at the commission that we do a lot of grants, and that usually scares the living heck out of me when we get a one-time allocation, because it goes to exactly what your next question is: how do we sustain anything we're just beginning to build? We received assurances legislatively that this is something that they understand should be an ongoing need across the state. And so even in this somewhat challenging budget environment we're about to enter, that's something that we expect the legislature to support. I think the big question that we need to answer, and we're working with our legislative partners on, is what is the right amount of money? So this first $18.5 million was a 1-year, one-time investment, but now we need to move into those biennial budgets. And so through the governor's budget process, our agency has submitted a request for $50 million across the state. We're hoping to get close to that, though we won't know until the governor's budget comes out in a few months what that final number will be. And then we'll move on to working with our legislative partners to try to, again, hone in that need. And so one thing we're soliciting from our grantees is we know what the amount is they got this time, but we're also asking them, what would you really need to stand this program up, realistically? And so that we can also pass that information on to the legislature so that they can begin to consider what those next steps are.
Thank you so much.
Thank you, Ron.
I don't see any more hands, so I have another question regarding the conditional discharge. At what point would the person who's being charged be advised of the conditional discharge option? And who would be doing that advising?
That would certainly fall to their defense attorney. So hopefully that is now that it is more of a mandated option. That is something that I would expect. I spent a hot minute as a public defender as a young man. That would be one of the first things I know that I would mention to my client if it seemed advantageous to them, given their situation. But that's something that should be known pretty early, so that when they go to enter their plea, certainly they're going to enter a not guilty plea arraignment, and then they can engage in that discussion moving forward.
According to the chart, it would be if someone is refusing deflection, is going to arraignment. And so they would have a public offender or an attorney represent, or they'd have representation at the time that they move forward beyond post arraignment.
That's correct. Yes.
Okay.
And that's where too we saw, and so that's why we were a little concerned too. So some of the counties that are more restrictive. So if you're somebody who had a delivery conviction in your past, some counties are going to say, even if you have a possession misdemeanor only, you're not eligible. So those would be folks who would really, their main route is conditional discharge. And that's what they would be focused on, because they're not eligible for deflection. So it's both people who refuse, but then people who are ineligible because of the county restrictions that are put on. But I will mention that's something that we also worry a little bit about. One of the legislature wanted to minimize the impact on the system and minimize the number of public defenders we would need, given that we have around 3,000 cases that don't have a public defender right now. And so that's going to be some additional work on that already strained system. But that's where that advisement would most likely happen, Ron. Thank you for the question.
In all the counties, the 8 counties that are not doing deflection, this would apply to everyone that's arraigned on PCS charges.
Yeah, that would apply to the PCSU folks. Exactly. Yeah.
Okay. Thanks. Thank you.
Thank you.
Keisha, I see your hand.
Hey, yeah, I just had a quick question about the grant process. So with the applications coming out again for Measure 110, would it with the folks who already got funding from, I can't say all those letters, CJ, from you guys, should they be applying for Measure 110 funds
That's a great question, Lakeisha. So
like the counties?
certainly, certainly. So I think that Senator Lieber has put it very well, who is one of the co-chairs who led this effort to create this program. What we sought to do at CJC was to build the bridge between criminal justice and the public health entities that you all fund. If a county did not engage in asking for your money for its treatment capacity, then we would actually be building a bridge to nowhere. So I would actually strongly advise every county, and then also advise you all to continue to provide this amazing, robust funding to local treatment, because that's what we're hoping to push people towards. We are funding some of that behavioral health capacity, but it's really, I would say it's on top of perhaps the funding that you are giving. And so I would strongly encourage counties to continue to take advantage of what you all have.
So so you're saying they should, because
Yes.
a lot of the money that's going to the counties aren't going to the like community-based organizations. They're not part of that. But it's gonna be a big strain on the community-based organizations with this deflection, because who are you deflecting to but these community-based organizations
Right.
without
Yeah.
pouring no more money into them?
Yeah. Yes. There are some community-based organizations in our grant receiving money, but yes, it is much more of a governmental buildup, I would say. So, but that's also why we're requesting additional funds beyond, as you saw. So we have this around 20 million this biennium. We're requesting additional funds to hopefully continue to build up that capacity moving forward.
Melinda, I think you're next.
Thank you. So I just wanted to know, if I heard you correctly, you said that if you have a prior charge, a felony, like for instance, burglary, and you get picked up for possession, you can't go into deflection because of that prior charge?
It would be a prior conviction, not just a prior charge, but in the counties that have set their eligibility criteria strictly, that is correct. That's not true for every county, but that is true for about a third of the counties, where if you had a prior conviction for certain types of felonies, or if you were picked up for co-occurring charges at the same time, that you would not be eligible. So yes, we're very concerned about otherwise deflection eligible folks who would not be able to enter in that program because of their criminal history.
Right. That's not making any sense to me, because it seems like people that I work with the homeless population, and they receive a lot of tickets for loitering or trespassing, or just for being homeless. They get ticketed. So how is that going to help someone that's trying to come out of their addiction? I don't see how that's going to help. I don't see how that's going to help for those counties that put that in place, because I don't know anyone that has a criminal history that just did it one time and that was it.
Sure, and I do want to make sure that I'm very clear. Most of the criminal history requirements that counties have put into place are for violent criminal histories. That doesn't necessarily change the fact that I actually share your concern 100% with having criminal history as being a determinant for program eligibility now. I completely agree with you 100%. But for the most part, when we do think of some of the crimes that you just mentioned, loitering and others, those from a criminal history standpoint would not make somebody ineligible. But there are some jurisdictions where if you had loitering and possession, then you would be ineligible. And again, I completely share your concern and agree with your statement that probably is not very helpful for that type of person. I think really for me, I try to take a page from, again, the Seattle LEAD program, that these are folks who have very complex needs, very complex criminal histories, and oftentimes a lot of things going on at the same time. And certainly they need help just as much as others. And so I completely agree with you, Melinda, on that. And that's something that I think through our best practices that we hope to show to counties. And like I said, the issue is that we lack statutory authority to do much more than advise on those things.
Thank you.
Thank you.
Well, I want to just acknowledge that we have one more presentation, and also can, thank you for all of the detail and the presentation. But before we, and we'll have the slides, and of course, always more opportunities to discuss, and even can come back or whatever the council needs. But I want to open it one last time for any last minute questions before we have Nancy begin with her portion of the presentation.
Thank you, Sam. I really appreciate the opportunity. Yes, I'd be happy to come back. I appreciate it.
Thank you. Much appreciated. Nancy, I think you're up.
Great. Thank you so much. And thanks everyone for having me today. And thanks, Ken, for that really great presentation that provides so much detail to really understand kind of these programs and what we're headed into. So I did have some slides originally that may have overlapped a little bit with what Ken shared. So if I breeze through some of them, that's why. So my name is Nancy Goff. I'm the Health Policy Director for the Oregon Rural Practice-Based Research Network. That's a big name. Our acronym is ORPRN, and that's at Oregon Health and Sciences University. My colleague, Dr. Dan Hoover, is the lead for the deflection technical assistance work that I will talk about today. He had a conflict today with this presentation, so I'm sitting in for him, and I will do my best to share information with you and answer your questions, but thank you in advance for your patience if you have questions today that I can't answer, and I can just get back to you. So first, I wanted to share a little bit with you about the support that our team is providing for counties to stand up the deflection programs. Then I'll talk a little bit about what deflection is and isn't, and I think you've heard some about that today, so I'll try to keep that brief. Then I'll address some kind of frequent questions that come up about designing deflection programs. And finally, I wanted to share just a couple of examples of initial program plans from some of the counties that we are working with. So throughout the presentation, please feel free to drop your questions in the chat, and I will take a look at them and respond after the presentation. And just to give you a little bit of an overview before I go on to the next slide, just to share a little bit about why Dr. Hoover and I have been invited to speak here. So Ken mentioned that we are a grantee of the Criminal Justice Commission as well. So they're providing us support to provide technical assistance to Oregon counties that are receiving the behavioral health deflection grants as they stand up their programs. We have two ongoing programs at OHSU that really are a natural fit for deflection technical assistance in terms of standing up a statewide technical assistance center. So the first one I wanted to mention is the Oregon ECHO Network. ECHO is an interactive educational and community building experience that allows healthcare professionals and others as well to come together over video connection to learn about specialty care. So it really started out prior to COVID, but obviously COVID has expanded our use of Zoom for things. But we have these case-based learning environments. We have dozens of ECHO programs that happen over the course of the year, and Dr. Hoover has been leading our behavioral health ECHO program for many years. And in these ECHOs, he connects frequently with physicians and other healthcare providers and their community partners from around the state to talk specifically about specialty care for behavioral health and substance use disorder. So that's one program, the ECHO program. The other one is the ORPRN Health Policy Unit, which is my team. So we partner frequently with state agencies to help them implement new policies statewide. So state agency has a policy that is new, and we tap into our statewide network of staff and partners to help implement them. So we utilize our expertise in kind of building connections across diverse organizations, in this case, behavioral health and law enforcement, building these sustainable systems to support collaboration, and removing barriers, whatever barriers might exist to that work. So between those two programs, we found a natural home for the Deflection Technical Assistance Center. And I'll talk a little bit more about what that looks like. So next slide, please. So this slide is just a heads up to let you know that there is another team from OHSU that is also working on data collection, analysis, and reporting that is required by House Bill 4002. And they also happen to be at OHSU. So I didn't want folks to get confused in case you'd heard of them or you're interfacing with them. So that's the team on the right-hand side. That's the data team led by Dr. Elizabeth Waddell. You can see them on the slide, those 4 folks there. On the left-hand side is Dr. Hoover and I, and the programs that I just described. So just know that there is another data team from OHSU as well. So next slide, please. So within our technical assistance team, we're working with local and national subject matter experts. So the local subject matter experts are behavioral health and law enforcement folks from Oregon that have been leaders or champions in the work already and have expertise to share with their peers. The national experts are from the Center for Health and Justice, and I'll describe them more in a minute. And in addition to that, I mentioned we have regionally embedded staff who are our coaches from ORPRN. They're in communities across the state. They live and work in their communities and have relationships with all kinds of public sector, government, healthcare folks there. And they do ongoing work to help teams move towards their goals. So they're trained in things like community engagement, quality improvement, systems change, in case any of those terms resonate with you. So those are our coaches. And between the coaches, the local subject matter experts, or SMEs, I think it says SME on the slide there, the national experts, and Dan, Dr. Hoover, and I, like, this is our TA team. So next slide, please. So who are the national experts? TASK is the Treatment Alternatives for Safe Communities at the Center for Health and Justice. So here's some information about them. So their work is grounded in 46 years of experience in specialized justice and health case management. They advise across all 6 deflection pathways. So officer initiated, which Ken talked about earlier in terms of the LEAD program. That's one pathway, but there are multiple other pathways, and Center for Health and Justice does advise on all of those. They have TA partnerships where they provide technical assistance to over 75 deflection sites nationally. They serve as the Department of Justice Bureau of Justice Assistance National Deflection TA Center, and they've partnered with Illinois statewide deflection initiative in all 102 counties in Illinois. So they're not just consultants on process, they're also doing the work and they're sharing their experiences as well. So next slide, please. This is an overview of the TA activities and events in our year of supporting counties, our first year here partnering with CJC. So in July, we hosted 3 regional day-long events, one in Baker City, one in Portland, and one in Bend, to kick off programs. So our national experts at CHJ, Center for Health and Justice, that I just mentioned, they trained counties at these events, and they were focused really on 2 things. The first thing was level setting about deflection, getting us all on the same page about what it is and what it means and what it looks like. And then the second piece was for individual teams to get a highly facilitated experience of walking through a process to start to articulate and define the key elements of their individual programs. So things that Ken talked about, like what constitutes success for a deflection program and how long should someone be engaged, those types of things they started to talk through. And then now that those trainings are over, we've moved into the phase on the bottom, July through May 2025, which is individual county virtual ongoing technical assistance. So our coaches and subject matter experts, local and national, are meeting ongoing with the teams to kind of meet them where they're at and provide what they need to be able to create really robust programs that are informed by national best practices. And then September 1st, just a few days away, as you know, counties will start to operate their programs. Next slide, please. This is going to be a little bit too much of a review for you, so I'll kind of skim through this quickly about deflection generally. So the first question we usually get from folks when we're starting a talk about deflection is, how is it different from diversion? So I think you already know this. You can kind of keep clicking through until all the diversion things come up on the slide. Essentially, deflection prior to, oh, one slide back. Deflection is prior to or without arrest. Diversion is after arrest or booking. Where it's centered, so deflection typically is centered in the community and community services provision, and diversion centered in criminal legal proceedings. And the focus for deflection is on pre-arrest diversion. Focus for diversion is on minimizing further system involvement and minimizing jail or prison time. Next slide, please. And this is just another picture to kind of get at the same, illustrate the same concept that diversion is typically has a larger role of the criminal legal system. And then next slide, please. Deflection has a larger role for community. This is pretty typical. And so, like I mentioned, this is one model among many, the officer intervention deflection, but since most of the counties in Oregon are really focused on this model, that's what we're highlighting here. And next slide. So I want to show some examples of what is the process of kind of walking through deflection look like for an individual participant. And there are challenges, in getting from intake to completion. So this is a very simple graphic, but essentially law enforcement contact with a person is initiated, a handoff is made to the deflection team. Multiple pathways and partners could possibly be activated for the person deflected. So it could be anything: crisis response, SUD treatment, mental health care, case management, peer recovery, social services, or many of the above at the same time, and more. So a lot is available there to a person. And finally, there's feedback to law enforcement about whether deflection was quote unquote successful. And as you know from what Ken just shared, there are different definitions among counties about what constitutes success. So next slide, please. And so the next two, and you can kind of click through a few times there. Yeah, so really this slide is just to demonstrate that we want programs to be successful, and we are learning about what makes programs successful. And one of the things that we're learning from other states is that there is value in really scaling the initial deflection programs to the current resources available in a community. So in the beginning, make your program small and scale it back to the resources you have available. This shows early success when you're pilot testing your program, and then that can be grown over time. You've seen examples of that, I think, in some of the materials Ken shared, but the ways that teams are doing that is really they are either kind of scaling back their population in terms of who's eligible and the enrollment criteria with a smaller population if they need to, based on the data that shows the biggest treatment needs in their community. So for example, when we were in Baker City, I worked with a county in Eastern Oregon at the training. They said their biggest need right now is in males between age of 20 and 40. So they are going to scale back their initial program to that population. And that will allow them to make sure that every person that is deflected has access to the services they need, and there isn't a gap between the handoff from law enforcement to the services in their community. And next slide, please. Again, illustrating the same point on this next slide. If you could keep clicking through, and one more. Yeah. So if there isn't enough capacity, then you can keep clicking through there. You can see that there are poor results, loss of trust in the community and with law enforcement, and keep clicking through there. And law enforcement not as interested in deflecting. This is kind of like a downward spiral for programs. And that's where deflection programs end up collapsing. So we really want to set teams up for success in the beginning. And again, one way that we're doing that is helping them to scale their programs to the resources available. So next slide, please. So the behavioral health deflection grant that's split between the programs, Ken shared with you kind of where the funding is going. It's not an enormous amount of money to operate or launch these new programs or provide new recovery support or treatment services. So what we're really trying to focus on with our TA is the linkages. So linkages between the officer, between law enforcement, and behavioral health treatment to care to other social service needs, housing, etc. What do those linkages look like across communities, and how can we build them so that they are sustainable and consistent and people really know about them? So that's how it's also described in the legislation. So you can see that there, and it's not building new services in particular with these programs, but creating a linkage and leveraging the officer contacts. So as Ken mentioned, all the deflection programs are required to partner with at least one burn organization in their county. So deflection programs should be acting in synergy with the recovery support and treatment already available through their local burn. So this is one area where there's an opportunity for partnership. So I just wanted to call that out. The next slide, please. So next several slides just talk a little bit about some of the FAQs that we hear and what are the things that as we're standing up programs we're really focusing on to make them most successful. The first one and is officer buy-in. So officer buy-in is of primary importance in these programs. Officer buy-in requires executive leadership support within their organization, clear policies and procedures, telling officers what they need to do and when and how. The deflection referral must be easier than booking to jail. And training in the science of substance use disorder for officers is important so that they can understand, at least just kind of scratching the surface on what they need to know about addiction medicine. So that's really important. So we are starting some law enforcement and police trainings in the fall. We'll be focused on deflection programs with earlier launch dates, and these trainings are led by OHSU Addiction Medicine and will include staff from law enforcement and crisis response backgrounds. So we're leveraging those folks that have had early successes or kind of champions in their field to be able to speak with their peers about what they've done. So next slide, please. Now I wanted to talk a little bit about enrollment criteria. I think we already talked a bit about this already, just to get at the point I was making earlier about scaling your program to the resources you have available. So counties can decide whether they want wide versus narrow criteria about how many people are eligible, and this will impact the number of participants and also the service capacity, volume, and type of services. So it's a big consideration. And one consideration about starting with the PCS drug enforcement misdemeanor charge as a common starting point for most programs. One thing I don't know if downside might be overstating it, but one complication there is that people who use drugs and encounter police may have other kind of low-level misdemeanor charges that accompany possession. And so counties are already starting to think about, expansion. Some of the folks that we're working with in Illinois are designing deflection programs, not just for substance use disorder, but for other things as well, like some of these other low-level crimes alongside drug use. So it's something to think about as counties are designing programs, like what are they potentially kind of building up to in the future, and what is that crossover between the drug enforcement misdemeanor charge and other low-level charges as well. And next slide, please. I would say if you ask our national expert partners about what's the most important piece of the puzzle for deflection success, this would be it. So this means that the efforts to reach people are continuous and persistent, and they don't stop until people are ready to engage with treatment. So this is relentless engagement, and this can happen from multiple types of roles. So navigators or engagement specialists, case managers, deflection coordinators, certified recovery peers. There are a ton of folks that are already working within the behavioral health system that are out there ready to provide that warm handoff and to be the first touch point with folks that are deflected. So many different titles, many different roles. I think that the Behavioral Health Resource Network providers who are already doing outreach for this population, there might be some opportunities there to align that and sort of coordinate with the efforts that are already going on with people who know how to do this well and are really good at engagement. And we have heard that certified recovery peers could have a large role in the new deflection programs. The ones that are in our behavioral health workforce will definitely be involved, and supporting them in this new role is really important and something our TA is starting to help with. So we're thinking about how can we support folks in the peer role right now to be able to get involved with deflection programs. And so next slide, please. I think I'm gonna probably skip this. Ken talked about what counts for success already, so we don't need to continue to talk about that. It's different for every county. Okay, so now I just wanted to give you a couple of examples of initial program design in some of the counties we're working with. So next slide, please. Baker County. So Baker has countywide access to the program by police and sheriff's office. Their engagement plan is officer citation. The participant is required to present within 3 business days to community mental health program or burn service provider. And in this case, it's New Directions Northwest. And in parallel to that, New Directions peers will conduct outreach. And then ongoing deflection coordination. So there are regular meetings of the deflection coordinator, law enforcement, the DA's office, and New Directions to review participants that are in deflection and re-attempt engagement efforts by burn peer team or the mobile crisis team. So that's Baker County. Next slide, please. So the next one is Jackson County. So the way that they are going about it is they have a designated policing team, which is the Medford Livability Team, and a designated area, which is called the Greenway. So again, this is a way for them to kind of scale back their program to meet resources, as they're using a geographical area to define where they'll be deflecting folks from versus scaling down their population. Their engagement plan is response to the scene by a certified recovery peer. And their deflection team includes a coordinator, multiple certified recovery peers that are employed as substance use treatment partners and burn providers. And those are the names of some of the folks in that area. Next slide, please. Clatsop County. So they have countywide access to the program by police and the sheriff's office, similar to Baker County. Their engagement plan is regional warm handoff at a scene, regional police drop-off to Clatsop Behavioral Health Rapid Access Clinic, and otherwise 72-hour citation to appear in clinic. The deflection team includes a coordinator within the sheriff's office and certified recovery peers and alcohol and drug counselors employed at Clatsop Behavioral Health. And next slide, please. Finally, Washington County. Washington County's enrollment criteria includes the PCSU charge, a countywide access to the program by police and sheriff's office, again, same as Baker and Jackson. And then the engagement plan is officer citation. The participant is required to contact the deflection team. The large metro area pilots include warm handoff and peer engagement in Hillsborough and Beaverton. And success, if they're assessed to need SUD treatment, then success would be engaging and progressing in their SUD treatment. So next slide, please. So now in this slide deck, which I think you'll receive afterwards, there are lots of resources. I'm not going to go through them all here, but there are multiple slides that you can look at if, say, you want to look at how to learn more about deflection generally, how to learn more about the critical elements of deflection. There's a link to an e-course that you can take, learning about like officer support, learning about the LEAD program. So there's lots in there. There's also the contact information for myself and Dr. Hoover at the end if you need to reach out about anything. So I'm going to stop there and take any questions that you might have.
I don't have any questions, but I just wanted to say thank you for covering that. That is a lot of information. You did a really good job of sharing it.
Thank you.
You're welcome.
I know it's late in the day, and I appreciate you all kind of staying tuned in. I know I had to get a snack for myself while Ken was talking, so I understand if people need to be stretching or doing other things for a while. Any other questions?
Thank you, Nancy. I'm just going to step in because Sam's power went out and she was disconnected from the meeting. So if there's no other questions, I'll pass it back to Melinda to close the meeting out.
Again, thank you, Nancy. Wonderful presentation. If we don't have anything else, do we have any OIT updates?
We do, but Sam has those. We
Okay.
can, I can send out an email with those updates after I get in touch with her.
Okay, so the RFG updates and the Q6 thing we're gonna have to do through email, correct?
Well, I'll talk to her, either email or I can give y'all a call.
Okay. All right, well, I guess that concludes our meeting today. Thank you all for attending, and I'll give you back the rest of your day. Thank you.
Thank you. Bye, everyone.
Thank you, everybody. Bye. Sorry I was late.